Once again, we gather in search of the truth, dark, and mystery. It's the Drunk Turkey Show.
Big development today in the investigation into the murders of 4 University of Idaho students. According to state and local officials and court documents, 28-year-old Bryan Christopher Kohberger has been arrested. He was arrested and arraigned this morning in Pennsylvania.
We have new details on what Bryan Kohberger was doing right before his arrest. Police says a tactical team burst in to arrest the Idaho murder suspect. He was in pajamas and latest gloves, stuffing trash into Ziploc bags.
Hey, greetings from the year 3000. It still sucks. This is Philip J. Fry, and you're listening to the Drunken Turkey Show. Your one stop for this sort of thing. Hit that button, like and subscribe. You know what to do, just like every other podcast.
Just like every other podcast. What is up, everybody? Welcome back to the DT Show. I'm Daniel, and today we're talking about Bryan Kohberger yet again. There's a couple of hearings that are going to be coming out this week, so you'll probably be seeing me go live maybe the next few days in a row. So make sure you hit that like button. Make sure you ring that notification bell so you're notified of every time we do go live, so that way you catch all of our daily or all of our content, that comes along with this case and other cases as well. I want to thank also all your new subscribers. We had quite a few since we had Kevin on from the Yellow Cottage Tales YouTube channel. So I want to say shout out to everybody that has joined us from his channel. Thank you so much for tuning. And without further ado, let's get into this. But before we do, I want to thank our members, our mods, and subscribers, and just tuners in the building. We appreciate you guys being here. All righty. So without further ado, let's break it down. Let's get into it. There was a surprise hearing today. And I say surprise because it wasn't on the docket or anything. It just kind of populated. And let's see. And what ended up happening is there was a court hearing. Let's pull this up real quick. Now, I've heard most of it already once. I do kind of want to go through it one more time. There's also some court documents that have been shared referencing this, but there was some things that I had heard throughout this when I was listening to this while I was at work that kind of caught my attention, and I want to make sure that we cover these things. It's going to be pretty quick. I have it sped up, and we're going to be going over the important parts. So if you haven't heard or haven't seen the important parts of the trial or the hearing that was happened today, it's going to be a good time to check that out right now. So without further ado, let's get that going.
I'm not sure if Ms. Olson or Mr. Peterson is addressing the court today, but whomever is may address the court.
Thank you, Your Honor. It will be Ms. Olson on behalf of the interested parties, who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding press and public access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Brooklier have addressed the issue. Waller did so in the Sixth Amendment context. Brooklier found that the First Amendment right of access extends to suppression hearings, and an associated.
Alrighty, so this is just basically saying that the media wants to have access to the court and things of that nature, and they want to have access to more information. So let's kind of fast forward that a little bit.
And the Brooklier case involved a RICO prosecution, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions.
So she's basically talking about why it's important to have the media in the public, in the hearings and things of that nature. And basically what she's saying is, one, the public has a right to know. Two, this is kind of like a check and balance to ensure that nobody's getting screwed over one way or another. And three, it's a way to, for them to get clicks and views, to be honest with you. That's what they want. But That's their stance on there. And I mean, it's a solid stance. It's not too bad. It's just at the end of the day, his right for a fair trial is a little bit more important. You don't want to taint the jury, and I think the judge mentions this a little bit later in this hearing, but the thing is, this trial was moved from one location to another in efforts to minimize the amount of information that was going on, and this was at the defense's request. Remember, this wasn't the prosecution's request for the change of venue. This was the defense's request for the change of venue. And the reason behind it was that they wanted to find a jury pool that wasn't tainted. By putting out information that may or may not be admissible in court is not a way of giving him a fair trial, in my opinion. Just it doesn't make sense. It's counterintuitive to itself and what they're trying to accomplish. And well, let's carry on. Let's see what else they have to say.
And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, a court must afford those excluded from the proceeding reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirements set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings, the interest parties are not arguing for a blanket order opening the court for its closure.
I'm just going to fast forward this part.
Oregonian 920 F. 2nd at 1467 and Brookler 685 F. 2nd at 1167. As we understand it, Your Honor, the non-dissemination order and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in court proceedings are opinions. In Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to the issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court.
All right, here's what I wanted to get
Sufficiently
to.
like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary.
So that she basically laid it all out there, right? What the Franks hearing is going to be about, what the IGG is about, and what the defense's basically their whole argument is when it comes to the Franks hearing, when it comes to trying to get a bunch of this stuff thrown out. And it's something that I said maybe a year and a half to 2 years ago at this point, getting close to it. I mean, it was probably about 5 or 6 months after the murders had occurred, when, his arrest had been made and we find out about the IGG and we find out how they were able to connect the dots. I told you guys when they had the hearing where Corporal Payne was on the stand there, and he was talking with Ann Taylor was grilling him, and they were grilling about when it was that she had made contact, or when it was that Payne had made contact with the WSU officer that found his vehicle. And they were complaining about when that happened. And then in the hearings preceding that, up to that point, they were wanting to get a bunch of evidence that referred to the timeline of when the prosecution, law enforcement got Bryan Kohberger's name, when they changed that they were looking from a 2011 to a 2013 Elantra and such. And I was able to put the dots together over about maybe a year and a half ago, that the defense's claim is going to be, and this is back in Judge's hearings, and you guys can go back and watch them. But I stated that the claim was going to be that the defense is going to go and say that the way they found Bryan Kohberger's name is through the IGG. That is how they were turned on to his name. That's the way that they got him. However, that is not what they're explaining in open jury trial or an open court. Well, it's not open, in closed court with a grand jury, right? The grand jury, they weren't privileged to the IGG information. It's inadmissible in court. So it's not being used in any document that I'm aware of. I know that some folks will say that the document in Washington for the search warrant, I think that was referencing the familial DNA is what it said. And what that was that they had the father's DNA. It matched to the father. They hadn't yet tested Bryan Kohberger's DNA yet. They hadn't buccal swabbed him. So they were saying that, hey, we don't believe this is going to come out in the favor of Bryan Kohberger, but if it does, we don't want you to use this as what do you call it? Probable cause. And that's because they didn't test the DNA, right? Well, anyways, I had said that they were going to go in there and try to say that the law enforcement officer lied in grand jury, and that how can you trust them? They're liars, blah, blah, blah. And this is the whole reason why they wanted an open court too, because in the end, when it comes down to this hearing, the reason why they wanted an open court is because this stuff isn't going to be argued in trial, right? And two, they wanted an open court because they can get this information out there. They want to try this case in public opinion, but they want to try it with the prosecution's hands tied behind their back. Meaning they only want to try this case in the court of public opinion with the information that they want out there, and any information that may say something differently about what Bryan Kohberger may or may not have done. For instance, the total lack of DNA and not allowing the prosecution to come back and say, oh yeah, there is some, those type of things because of a gag order. That's how they kind of want things to be placed. They want the seal to be on there for any rebuttal, any objection, any of those things on the state's part, but they want their part that they feel comfortable, which is not everything, because there's some things that they want not to be in the public record, and there are some things that they want in public record. So they're trying to fight this, trying to try this in the court of public opinion, which tells me one thing. If you're not pounding the table for the facts and the evidence, and you're doing it for, all this stuff for, pre-trial where the prosecution can't argue back or any of those type of things, at least publicly, they're going to have their arguments and things like that behind closed doors. So that way it doesn't give the evidence isn't put out there ahead of time, ahead of getting a jury and things like that before that happens, thus could potentially taint that jury. So that's basically everything that I got from this lady here. She said a whole lot of stuff to get to the part that was important, which was the officers. Apparently they're claiming the defenses is that they lied by saying they got his information based off of a random contact with a WSU officer on November 25th, which resulted in a listed car with Bryan Kohberger's name on it, and that list coming to the detective and he finding, and that's how those dots connected. It's not how those dots connected, but either way, that doesn't really matter. I mean, wouldn't be the first time that, something inadmissible would be a way to find someone. One, IGG has been used in multiple cases before. So just on that case alone, or on that situation alone, it does have precedent when it's being used. And two, it's inadmissible evidence, right? Because they didn't tie it to the Bryan Kohberger's DNA off his cheek. So you can't use it. And it's just a failing argument. It's futile, because if you were to throw it out, and yes, Stephen says Judge Hippler denied the defense's motion to unseal the IGG, and I got that here. We're going to be looking at that as well. But yeah, the way this is going to end up is probably not going to be in the favor of Bryan Kohberger. I don't see them saying, all right, because they didn't tell the grand jury of an inadmissible means of gathering evidence against somebody that is and has been used as a tip before in other cases and is not used in any warrant or evidence against Bryan Kohberger. It's a futile point, which is what Judge had said. He just didn't have the backbone, in my opinion, to stand firmly on that. All right, let's continue this.
An actual Frank's hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Frank's hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life and liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual.
So I've often said that this has happened before. I personally had a case where there was a young lady who went to a party. The party was held by a federal agent and his spouse, and there was a house party with a couple of people that were in there. I'm not going to speak on which agency it was, but this party goer, this young lady, she goes to the party, and apparently what has been going on was that this agent was maybe perhaps taking drugs and selling them at his parties. And so she goes to the party, and somehow her purse gets stolen, or they kick her out, they lock her out, and they don't give her purse back. And so she contacts myself and law enforcement and tells us, hey, you might want to be aware of this party that's going on, or these parties that are going on. We have this federal agent who is apparently doing this, and or not even that. He just said that there was a federal agent that was selling dope at a party, and that he may be doing that more often. And that was about the only information they would give. Wouldn't testify, wouldn't talk about anything, wouldn't do any of those things. And so we had to come up with probable cause to arrest this person or search their home and do all those things. And so what we did was we watched the house for a while, and when they would have their parties, we'd see some people leaving, sometimes especially those that went in there, stopped for a short period of time and then left. And then what we would do is we would knock down those cars for traffic stops. And, little things, it doesn't take much, turning without using a signal light for 100 feet, you're not making a complete stop, those type of things, switching lanes without your signal light. And then once we get them pulled over, they're nervous, they understand things. We know what they're doing. So we have a dog unit, in the vicinity. And so we would search their car. Most of the time they'd give us permission, they'd freak out. And if they didn't, we would search their car with a dog on the outside. Once they got caught, everybody broke down and would tell everybody. I mean, nobody wants to go to jail. So all of them, every single person that we knocked down, I want to say it was at least 6 that we pulled over, told us some information. And so we started doing an investigation against him based off of that, off of the traffic stops, and them telling us where they were getting the narcotics from. We actually had evidence of the drugs. We had probable cause for the stops, and we were able to build a case against him and arrest him. And so those things happen. There's more than one way to skin a cat, and there's more than one way to get arrest warrants. There's more than one way to get searches and seizures and things of that nature. You just kind of have to know, a little bit of the tools of the trade, so to speak. Like, for instance, we had one guy who didn't want to let us search his vehicle. And so, we called the dog. The dog didn't catch anything. The guy was being, you could tell he was real nervous or whatever the case may have been. And so what we did was I arrested him. I arrested him for this traffic stop. He had ran a stop sign. And lo and behold, in the state of Texas, there's only two offenses that you can't get arrested for, and that's open container and speeding. Now, obviously, if you're speeding too much, then that becomes reckless driving, which is a different issue. And if you're the one consuming the alcohol beverage that is the open container, there's DWI and DUI for minors. And so you can get arrested for those, but if all you have is an open container and somebody else in the vehicle drinking it, and you, the operator, are not, you can't get arrested for that. And same for the speeding. Everything else you can. So you arrest the guy, then you do a tow. You tow the vehicle, and you have to do an inventory of inside the vehicle, and it's not very hard to find things once you do that. So there's more than one way to skin a cat, so to speak. And we were able to do those things 100% legal. We got the conviction. He pleaded guilty, whole 9 yards, and another one in the books. So yeah, I know that some folks, they'll watch like Law and Order SVU, I apologize, or CSI or whatever the case may be, and think that that's how things work, and it's not. All right, let's continue this.
Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Kohberger, I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. Would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person 1 or person 2, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients.
So what the press lady is saying is, when it comes to the relatives of Bryan Kohberger, to just use like initials and things like that, so that way it still keeps their privacy in place. I mean, I get it, but like if somebody figures that out, this is the reason why they don't want it out. If somebody were to figure out who these people are, do you think that these pro-burgers or these mob mentality folks that go out there and find people and want to interview them just because they have a long distance relationship, like relative relationship to these people? No, people are going to go bother them in their natural lives. Like, oh, did you know that, he's a vegan? Is there anybody else in your family that's vegan? Anybody else that suffers from, the snow thing? I mean, I can already see it, how crazy some of these folks would get harassing all these people. So I just see, I don't know. It seems like his family isn't supporting him, right? That's what Emily says. I don't know. I mean, I can't say one way or the other. I think they publicly came out one time, said that they have completely, what was the word that they used? They have, gosh darn it, what's the word I'm looking for? They had, with law enforcement, they completely told them everything that they knew, all that other stuff. I can't think of the word. Well, anyways, that was the last time that they said anything, that they cooperated. They had completely cooperated with law enforcement, and that they believe in the presumption of innocence. And that was basically all I saw as far as what they said. Can't tell you if they've said anything else or more or less, but that's what I know. All righty. Let's see.
Whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings. And those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media.
So I do agree that transparency and disclosure is something that is needed. I also agree that in this case, it could be more transparent. I wouldn't be opposed to it. I understand why they're doing it. They're doing it so that way Bryan Kohberger and his attorneys can't come back later and say, oh, they put all this information out there before the trial. We want an appeal, blah, 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 blah. And so I get why it's there. I don't necessarily agree with it. I think that they should be transparent. And if there was transparency, then there wouldn't be such a question mark in some of the things. I think a lot of questions would have been answered. A lot of those things where people were coming out of these theories out of their wahoo about all sorts of things, those would have been squashed a long time ago. And I mean, even Steve and the Goncalves family agree with that. In fact, I'll read you a little thing that he sent me that he said it was okay to relay to everybody. He said, when I asked, because we're talking about the, when we're talking about the gag order, he says, they've asked me to address lifting the, hold on, wait 1 second. 95% of the case is now sealed. There's barely any room left for public hearings. All Ann has to do is bring up a topic she claims needs addressing, and we're all kicked out. Yet the moment something might be a positive for her case, she wants it to be made public. We want everything to be public, with the only exception being crime scene photos of the victims. Those are unnecessary for either side. And I agree 100%. I agree with what his statement is. So, I think that in the end, I think everybody should want, transparency or more information that is out there, what it is that the police are doing, what is it that is going on throughout these court hearings. I don't disagree with that. Not at all, one bit.
Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make a record on behalf of the defense.
Beyond what you did yesterday?
All right. So Angel asked a question asking, what happened to the alleged interview where the G family supposedly said they were friendly with the K family? I'm guessing that's Kohberger. Was that total BS? 100% that's total BS. So what ended up happening was that Arthur Bloom went out there and wrote an article saying that perhaps that there was a witness that was mentioned in the grand jury, and that they were getting close to that person, and that the FBI told them to stop or something to that nature. For one, I have never asked Steve or his family if that is true. I have no information on any of that information. And to be honest with you, I wouldn't even ask him because, that's their business. But he claimed that was the case. And then there was other rumors and theories out there that one of the sisters had spoken. And so a lot of people were putting two and two together and saying that, all right, the sister spoke, Steve almost talked to somebody. It must have been the same person. And I can't tell you, I don't know if that's true or not. I'm assuming that's bull crap. I think I would have heard that, to be honest with you. It doesn't sound like they've ever spoken to anybody from the Kohberger family. From what I've gathered with my conversations with them, let me think. Yeah, no, not one time. I don't think I've ever asked about it, but I think I have asked if they've heard anything about the sister, perhaps speaking or anything like that. And he told me they weren't aware of anything like that. So I would assume that if there was something that was like that, then he would have been aware of it. So I don't know. Doesn't necessarily mean that it's not true that the sister was that person. It just means that I have zero idea. I doubt it, but I don't think that there was ever any communication between Kohberger's family and the G's. Let's see. And right, I mean, one thing about Steve's statement that is correct, if she thinks that the court is going, or the hearing is going in a way or a manner that she don't like, all she has to do is say, well, I'd like to address the IGG next, or something like that, that is sealed, and go down those routes, and then have to force everybody out of the courtroom. So it's it is what it is. But yeah, that's where that rumor comes from. It's a weak one, to be honest.
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
That was kind of it's funny. He's like, is it going to be the same thing you spoke about yesterday during the closed hearing? Because we already heard it. Like, I get it. I know what they're trying to say. The Daniel Turkey Show. No, it's not the Daniel Turkey Show.
So we had discussed
maybe Daniel's theories, maybe Drunk Turkey, maybe Daniel's thoughts. There's a lot of things it could be.
That the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks. The Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names, and in particular names of some lay witnesses, in directing the court to the 1,000 pages that were submitted into.
In some way witnesses. I think that's huge. Some way witnesses meaning that they witnessed something, right? They didn't witness Bryan Kohberger. They didn't witness, a lot of different things. It's a some way witness. So maybe perhaps that somebody saw a vehicle at a specific time at night, was able to identify something, or were able to help out, push something, that pointed in the area. Like, for instance, the gas station lady who found the vehicle of the white car traveling at that odd hour in the middle of the morning of November 13th, something to that nature. So, some way witnesses. It's interesting. And you got to remember, the way the defense words things is tricky. They are some wordsmiths, that is for sure.
To submitted under seal in relation to the proffer.
All right. Well, with respect to the names, I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
Anything from the state, Mr. Thompson?
Not me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
There's Mr. Thompson. I know a lot of people were worried about him, thinking maybe he wasn't on the case no more, wasn't the prosecutor. He is back in black and ready to rock and roll. He's not really wearing black, I don't think. That looks green. It's for the it's just the thought that counts.
Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
All right. Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case, in which it was clear the tract of the court and at the time the parties was to
Closest lay witness equals no expert witness. True. I thought they said some way. I mean, it could have been the lay witnesses. And again, I'm not an attorney either, so I don't know some of those terminologies, but appreciate that, Chloe.
To avoid, given the media scrutiny, the potential for impacting the jury pool that exists here, with evidence that may ultimately not exist and evidence that may not ultimately be admissible.
And that's exactly the point that I've been making myself is, why do you want to put something out there in the public that may not be admissible and may not even exist, or potentially taint the jury? It just really doesn't make any sense.
That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. It's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the
So, which also includes the fact that law enforcement may not have, when they told the grand jury that Bryan Kohberger's name came up because of, his vehicle was found on November 25th, which is true. His vehicle was found November 25th, and it was documented, which also does help out the case for the fact that they were looking for a vehicle that was similar to a 2011 to 2013 Hyundai Elantra. And the reason why I say that is because they had other vehicles that were documented that weren't a 2011 to 2013 Hyundai Elantra, meaning they were looking for vehicles that were similar to, which is what they said, and they'd be different had they not had anything else on their documents or listed or written down that was outside of a 2011, 2013 Hyundai Elantra. If that didn't exist and there was just that one, you might have something to stand on there. But if they had other vehicles, which it appears that they did, because at the time when they got this vehicle and they were documenting it, was well before the IGG came back, and was well before Bryan Kohberger's name was known to any of the law enforcement agencies that were investigating. So we can, because of that and that alone, that tells us that they weren't, harping down for a specific year, make, and model.
parties yesterday particularly sensitive about closing things when we don't need to. And I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues,
I want to hear that again.
Exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to. And I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues.
It sounds like both sides have been asking things to seal for no random reason. Like I said, transparency would be good on both sides. I'd appreciate it. I know everybody else would.
Particularly where I don't exactly know what the evidence will be forthcoming. I am concerned about the potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here.
I bet you Ann Taylor and the other attorneys that were speaking on the defense that have their cameras turned off are probably doing the biggest eye roll or the biggest, like, are you kidding me? Look right now. And they only do it because their camera's off. Like, just something I was thinking about is like, man, he's going in and he's telling them, hey, you guys were the ones that said that there was a problem with finding a jury that doesn't have knowledge of the case before. And now you're the ones that are asking for all this information to go out there. When it's the reason why they're even in his courtroom is because they said that they couldn't find a place, or they couldn't get a fair trial with a impartial jury in the location they were at due to the amount of information that has been let out. So it's pretty it goes against itself in a certain way when it comes to how the defense is doing this.
In Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions in limine and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And is that for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to the parties in the courtroom because of the need to close it if I find, or the parties suggest to me, and I agree, there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly, to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed, because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Frank's hearing as it relates to IGG in a closed environment. I think we can decide at that time before we go online whether we can have the IGG portion of the Frank's proffer publicly. The intent is, I think we understood from discussion yesterday, that the rest of the evidence and the arguments, both on Frank's and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, but the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case.
So there you go. The unwarranted concern for harassment. You know, if there ends up being somebody that was close to Bryan Kohberger, who ended up being the person who entered their DNA into, one of those DNA websites, people are going to harass them. People are going to go out there and do those things. But what it also tells me as well, when he's talking about that potential evidence that we're not going to see, blah, 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 that is referring to the IGG itself. Now, the IGG itself is in a instance evidence, right, where it points to the direction of the killer. It is not something that benefits Bryan Kohberger. The IGG said that it was him that committed the crime. Now how you test the IGG to determine how accurate that it was is when you do get your suspect and you get their DNA and you check it, it comes back as a match. If it doesn't come back as a match, and it comes back as a cousin or something else, closely related, that means you went down the wrong family tree. Right? And so you got to start back up at the beginning. going back at least however many, depending on how close they are. So for instance, if they started off with like a third cousin, you know, 3 times removed, and they end up with like a second cousin, well, now you know that the second cousin has, what is that, like great grandparents that is in common with the person that did it, and you can go from that point and start building your tree down. And so I get that aspect of it, but what they're basically also saying is that that evidence points to Bryan Kohberger. That evidence may not be allowed, or is obviously is not admissible in court. So why they want to bring it up so bad, something that points to the guilt of their client, you know, it is something that they may not be able to use, and it's going to look bad against their client. Now, the reason why they want it out there is because they want to be able to prove that that is how they got Bryan Kohberger's name, and that is what led them on this investigation, not that it was a random WSU officer. And as I mentioned before in the show, that's just how things work sometimes. You got to build a case. It's always not as cut as clear as straightforward as you think. Sometimes you got to build the case. You got to actually do some work. You got to go out there, and like I mentioned in the scenario that I had spoken about with myself, we had to go out there and find a few people who got popped with some narcotics and had to get them to dime out the guy. You know, just having somebody say, "Oh, there's drugs in the house," or "This is what's happening," and then runs off and we never hear from them again, that doesn't give us the right to go in there and search their home or do any of those things. And so, you know, you still need to build a case and get a warrant for it, which requires other reasons. But yeah, Emily goes, I like how he calls them out, the judge. I do too. Let's finish this up, and then we're going to read some of the documents that came out today.
We can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed, so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly, as was offered to me. That doesn't give me comfort, to be frank.
Boom, that's what I said earlier. What did I say? That they are trying, I didn't get this far into this hearing, that they're trying to get this done in public court. They're trying to try this in front of the world versus in trial in front of a jury. To me, this is another way of somebody, you know, pounding the table. Remember, I think it was Howard Bloom that said, you know, when you have an attorney that is confident in their case, they're pounding the facts and the evidence. And when you don't, they pound the table on a bunch of things and motions and appeals and yada, yada, yada. That is exactly where we're at right here. Let's get those likes up, guys. Come on. We got 416 people up in here. Let's bring that up. We appreciate that. All right, continue here. But yeah, no, I said this earlier. Like I said, I didn't get a chance to watch this. I got to work pretty late. I only saw like, to the point where he mentioned there that it was that they wanted a roster of names, and that was about it. But I'm glad I'm listening to it all now,
Frank. But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel. I think it's better that we proceed in this fashion for now.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood judges, the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if the defense, if there is a statement that is made under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand Judge's prior order to be dealing with extrajudicial statements, because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with Judge's ruling at that time. I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. So, at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right, so I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime, I think I need to take this course, so I appreciate it.
That's the hearing. A lot of good stuff there. You know, I agree with a lot of the positions of the judge, and he said that he was going to have some orders out that day, and that he did. Let's go look at the orders that he had come up with. Let's see. Let me find them real quick. I may not have these all in order. So this is the order denying the motion to unseal the IGG suppression briefing hearing. So they denied the motion there to suppress or to unseal the IGG suppression briefing, and it just basically says before the court motion to unseal the IGG suppression briefing and hearing, during which the court denied the motion from the bench. This order memorizes that ruling. Defendant has observed that this case has garnered tense, if not overwhelming, national and international attention in the media. This has led to the sealing of several filings in this case, which contemplates sealing information temporarily when necessary to preserve the right to fair trial. And that's one of the things that I had liked about what Judge Hibbler said, is that in the end, everything will be unsealed. And that's true. I mean, I get it that Ann Taylor wants to show the world that the police department lied and they really used the IGG and it wasn't this way that they found him. But police tactics and things of that nature, this isn't something that is uncommon. You know, there's more than one way to skin a cat, you know, so to speak. All righty. Says defendant seeks the unsealing of the briefing as well as the hearing on the suppression motion. He points that the public has been long aware law enforcement used investigative genetic genealogy procedures to investigate the case. So that's there. That is what it is. The argument that Judge Hibbler had stated before, that and kind of what I was saying, is the evidence that was used against Bryan Kohberger that they're trying to suppress on the state side because they're not going to be using it against Bryan Kohberger in trial is the IGG. And that's all it's ever been. It's evidence against Bryan Kohberger. It's not evidence for Bryan Kohberger. It's evidence against him. And they can't use it. It's inadmissible. It's not something that we're going to be able to see in court. So There it is right there, black and white. The IGG investigation has been held from the public. Defendant contends that there is a significant and prejudicial misinformation circulating in the public eye about his guilt. Unsealing, he argues, he will correct such misinformation, such as his Sixth Amendment right to a public trial and preserve the public's First Amendment right to know what is going on in its courts. The state responds that it has no objection to unsealing the IGG evidence after trial, but doing so prior to trial possesses a significant risk of tainting the jury pool. All right, and the state's, let me see, his Sixth Amendment right to a public trial, and he's thinking that if they unseal this, that this is somehow going to right some misinformation that is out there. And I wonder what that misinformation could be. That his DNA match to the knife sheath was 1 in 5 point some octillion % or whatever. That there's not enough human beings who have ever lived. It could be somebody else. So, all right. Let's see. Let's continue this. The state points out that there is no dispute to this high prolific case, particularly in Idaho. It was transferred to Ada County from Latah County on the defendant's motion to change of venue. Defendant argued that the motion, that the small size of the jury veneer and the extensive inflammatory media coverage prevented him from receiving a fair trial in Latah County. While Ada County has larger jury pool to pull from than Latah County, the state is concerned that the risk of exposing a jury pool to evidence, particular evidence that may not be deemed admissible in trial, remains significant. And so it's all just the IGG. There's not something else that's going to be populating out there that they're not going to be able to use in trial or whatever. It's all the IGG, whether that's admissible or not. And in the end, it's not going to be admissible in trial. It's not, but it's not going to throw out anything else. Let's see. The potential that the IGG evidence will not be admitted in trial, and that the fact that most of the evidence in this case is still under seal. The court is concerned that releasing the IGG evidence by making briefing and testimony portions of the suppression hearing public goes to a great risk in tainting an already relatively limited jury pool, such as protection in yours to the benefit of the state and the defendant equally. I guess when you don't really have anything as far as a defense, you throw things out like this. But like I said, Judge himself said that this was a futile argument. And he was the guy that, got stepped on a lot. So I doubt that Hitler's going to fly for it. Order sealing defendant's supplemental witness list for motions. Oh, there's one thing I wanted to show you guys too, because everybody gets all bent out of shape because it said, like, for instance, they were like, oh my God, there's a video of Bryan Kohberger, because it says a video of suspect video 1. And what it meant was a video of suspect vehicle 1. And then there was another part where they were talking about, like, oh, they found the K-bar knife. I have confirmed 100% that document that says that they took the DNA off of the K-bar knife was missing the word sheath. It was supposed to be K-bar knife sheath on there. And so I don't know if they found it since. I mean, that's quite possible. But at the time that document was dropped, they hadn't found it yet. And the reason why I'm bringing those errors up is because guess what? We have another error right here before everybody starts freaking out and wondering what the ICC evidence is. It's the IGG evidence. But just to kind of show you guys that mistakes do happen, these folks are human beings. As you can see, there is a lot of documentation here. And for all these documents with significant amount of words and pages in each one of these documents that I'm scrolling through still that are all part of the Bryan Kohberger case, to think that you're going to be 100% accurate on all these is kind of ignorant. You know what I mean? I think you're going to find some typos. You're going to find some things. I'm still scrolling through Bryan Kohberger's. There it is. There's the top. So Bryan Kohberger's, let me show you somebody else's. This is somebody else right here, Jeremy Albert Best. And the criminal complaint was on 12/4/23. And he's got a little bit, but it's nowhere near comparison. I mean, I don't know if you guys can see the little bar out here to the right. I'm kind of circling with my mouse, but it could be a little small here. Let me make this bigger. Right underneath the drunk turkey emblem at the top, yeah, there's a little bar there. This is, see how far that bar is from the top, from where Jeremy started right here. It goes down just a little bit. Now let's go down to the end of Bryan Kohberger's. Just to give you an idea of how many documents there is. You see that little guy go all the way down? There it is, right here. And now you're going back into the state of Idaho versus Lori Vallow, and aka Lori Daybell. And just to kind of get an idea of what hers looks like, that's it. Wait, that was two of them actually. Right here to right here, and this is another guy from here to here. And so that just kind of tells you how many documents and how many things have gone into this case. It's outrageous. It's insane how many documents and sealed and unsealed stuff. And to think that nothing's going to be inaccurate, I think is a little bit much, right? Texas Ranger asked, I wonder if BK chose not to be there. I think so. You know, since it was virtual and it was on Zoom, it was probably at the at his defense attorney's request, especially since he's, from what I can see, this is my opinion, looks like he lacks emotion, remorse, and lacks feelings, and you can kind of see that in his face, right? He's got these weird eyes, right? In my opinion, they're just dark, evil eyes. I mean, he's got blue eyes, but I'm talking about when you look into him, it's been described that he's got a cold stare. And I think that I would think that if he was just standing there, and since he's going to be in, I would assume he would still be in, perhaps maybe somewhere in the jail, not necessarily in a suit. He'll be in a jumpsuit. Seeing him in that manner with that close, they're trying to keep him out of the media, right? They're trying to they don't want anybody zooming in on him for a reason, right? Now, if they thought you can zoom in on him and you can see empathy and you can see remorse, or you can see, somebody who potentially, isn't capable of doing this, then you're going to want them to zoom in, right? You're going to want to see the tears. You're going to want to see those things. But if this guy is just cold-blooded, straightforward, they're going to want you to zoom out as far as possible so that you don't see him, that you don't see his behaviors. Maybe perhaps you don't see the way he looks at certain people when they talk, those type of things. Analyzing his face and his features, analyzing when things are being said, like, oh, how does his face move when a victim's name is brought up, or the date that the murders happened is brought up, those type of things. So I do think that he would, most likely, it probably was in his best benefit to not show up in the Zoom. Let's see. He said he had a cold stare. A lot of people did, including myself. Let's see. BK is unreadable. I don't think so. I think it's pretty obvious that he lacks, in my opinion, he lacks certain emotions and things of that nature. Like, he doesn't look like he's scared. He doesn't look like he's worried or any of those things. He's just straightforward. And some folks are like that. But, and I know a lot of people are going to be like, well, I know a guy who's just like that. Nothing bothers him. He's not a person that commits a crime like this. But when you add everything together, right, you add the potential for lack of remorse and feelings, which we know he had at one point in his life because he wrote it down, right? He put that information out there, and it's been spread out, and it was at one point. Now, that doesn't mean everybody that, has problems with feelings or thinks that their dad is a sack of meat and they treat him like an a-hole. That doesn't mean that they're all going to turn into quadruple homicide murderers or any of those things, right? But those that do turn out that way, those that end up committing crimes like this, typically have those things in their past where there's some psychological issues, whether it's feelings with remorse or maybe even drug use. Now, a lot of people are looking at the, the stuff that like the antidepressants and those type of things and the effect that they have on children today. But Bryan Kohberger was on some pretty strong stuff for a while there in his past. And like I said, it doesn't necessarily mean that he did it, but the folks that typically act this way have those things in their past. It's like when I tell folks, everybody that is in the Border Patrol, they speak Spanish. They need to, right? That doesn't mean that everybody you run into that speaks Spanish is a Border Patrol agent. It's the same thing here. Most people that commit violent crimes and take the lives of multiple people in the manner that Bryan Kohberger did, methodically, one by one, well planned type of thing. They typically deal with those type of emotions. And so BK has Adam Land's eyes. Yeah, I mean, his eyes, that's not some secret, that his eyes are something else. But as far as unreadable, I don't think that's the case. I don't think so at all. In fact, his professor saw it out of him right away. That's why they started putting him on a disciplinary thing. His peers created something called a Bryan tally based on his disturbing behaviors, especially towards women and his professors. So to me, that's not a sign of somebody who is, hiding in, a wolf hiding in sheep's clothing. This is somebody who is kind of out there, he's showing himself. He's not hiding it very well. Let's see. All right. But yeah, so that was that. I wanted to show that and went through that one. So this is the one regarding the presentation of the IGG. And the one thing that I wanted to bring up is that the judge writes, so this is as discussed with the parties on January 21st, 2025 status conference, there is a significant evidentiary overlap between the defendant's motion to suppress the genetic information and the defendant's motion for a Frank's hearing insofar as it pertains to his proffer regarding law enforcement to use the genetic genealogy IGG. The hearing is set for January 23rd, 2025, and is not intended as a Frank's hearing. So when they talk about the IGG and its importance, this is not a Frank's hearing. In the interest of time and efficiency, the court will permit the parties to present their evidence on the IGG issue as if it were a Frank's hearing. So what this basically is telling me is that they're going to present it to their best bet, and that'll decide whether or not if they want to do a Frank's hearing on it. And they want to kill two birds in one stone. My assumption is the judge is probably not going to let it fly, which is why he wants to do it this way. So that way he can, say, all right, no, this isn't good enough, and there will be no Frank's hearing. So then it goes on to say, by permitting such evidence, the court is not concluding or implying that the defendant has satisfied the preliminary showing required by Franks on the IGG issue, nor is the court bound to consider the full extent of the evidence if it ultimately concludes defendant's proffer insufficient to warrant a Franks hearing on the matter. This is simply intended to as time and resource savings measure. So again, this is not to be like a Frank's hearing. This is to act, they're going to let it treat it as if, and basically what they're saying is they're not implying that the defendant has satisfied the preliminary showing required by Franks, which is why it's not a Frank's hearing. They have not gotten there to show that this is strong enough. And based on this document here, this is a preemptive thing. They want to get this trial going on the right date. And so he's going to say, basically, I'm doing it this way so that after we do this hearing, I can shut it down and they don't have to bring it up no more. And I like this approach. I like it once and for all. It's going to come in, shut it down. I think they're going to shut it down. I know the Kohbergers are thinking they'll probably get something done in their way. They probably have a timer for Friday or something that he's getting released. I don't know. But I believe that's just to shut down this complete argument. It's a waste of time. It's futile. It's been a waste of time. And he's getting prepared for that. All righty, guys. So that's all I got. I'll answer your questions if you have any. Put a couple of stars. If you dropped in a couple super chats, obviously I will definitely answer those comments and questions. If you have comments for me, I'm going to start going through them now. So if you asked me earlier, I would ask you if you re-ask the question, put a couple stars so I know you're talking to me and not talking to one of our other members or subscribers or our viewers in the chat. Let's see. People arguing about, let me see. Arguments, let me see. Pro Burgers versus Kohberger. Let me see. Yeah, please, questions, put some stars there. Kohberger looks like Jake Gyllenhaal and in the movie The Guilty. I haven't seen that movie. But if I had to take a guess, I think he looks more like Frankenstein's monster in Frankenstein than any of the other movies. But I'll have to check out the Guilty. I haven't seen that one. Frank's on the wattage? No, I'm not sure what that means. Let me see. Yeah, any questions, any comments, let me know. Angel comes in with one saying, do you think Judge Hippler should unseal or why or not and why? Well, I just don't think it's necessary to be out there. I think a lot of people will end up harassing some of the folks that end up showing up on Kohberger's family tree. I mean, you know, some folks found out about Bryan Kohberger having family in Las Vegas and in other places. His dad had a twin and or a set of twin brothers, and somebody found one, and I mean a bunch of other things. I think one had passed away, and people were reaching out to all these other people who were distant relatives at this point of Bryan Kohberger's who hadn't, you know, been around him in a long time, if you know, quite a while, and so I wouldn't be surprised. I mean, I heard, you know, from you guys in the live chat that when the Richard Allen case was going down, that people were following the jurors and taking videos of them. And, you know, this has obviously been a situation where Translucent says, why was I timed out for correcting the host? What did you correct me on, Translucent? I haven't seen what you did or didn't do, but I would like to see what you mean by that. Put a couple stars on there. I have no idea why you were there. And as far as why they shouldn't, I just don't think it's going to go anywhere. You know, why put out people's information out there that, you know, their argument is just futile? It's not going to do anything. Let's see. Daniel, we did cover the already to a certain extent, but could you speak from specifically your law enforcement experience about that eyes turning black look? I've encountered that before. I have encountered that before, and it is horrifying. Eyes turning black. Like if you just seen somebody who's just lost it, they're no longer there. I mean, I've seen a couple of people who have had situations like that. You know, one person had he was on drugs and he was walking around with like these razors between his fingernails or between his fingers. And he thought he was like Wolverine or something, but he was just super high and trying to stab people. And that guy, you could see that he was gone. I had one dude that I arrested who had, how can I put this? He took something that didn't belong to him from two little girls. One was his daughter, one was his stepdaughter. Both were under the age of 8. And that guy had like the most disgusting look, in my opinion. I mean, it was disgusting. And that's one of the things that I was talking about when, like, for instance, people look at Proctor and he said some horrible things about Karen Reed. Well, I'll be honest with you. I didn't say some nice things about that man I arrested that did that to those two little girls. You know, and in Proctor's point of view, Karen Reed is a cop killer, killed one of his brothers, you know. So take that for what it is. Ann Taylor just wasted all this time on the IGG and the Franks hearing. One was denied, and one will be denied. Now, do you think she will ask for an extension on the trial start date? Probably. It'll probably be also on the eve of when you can ask for it, just like she's done it all the time to try to get it extended. I wouldn't be surprised. Let's see. Do I think that the IGG connection is very close to the familial match? I have no idea. I would be speculating on who the IGG was. You know, it may be on his father's side. It could be a maternal match. The familial match was from the DNA that was found in the trash can. They didn't find Bryan Kohberger's DNA in his parents' trash can. The only DNA they found was DNA to his family members. And when they tested some DNA that was male, it happened to come back to the father of the suspect, which was indeed Michael Kohberger. And so because of that, his only son would be Bryan Kohberger. So that's how you were able to get that, where you were able to connect those dots. And so the IGG had nothing to do with the familial match. All that was that the DNA sample that they were collecting from the trash was his father's. Laugh out loud about Kohberger's having a timer for his release. No, I've literally seen it. I haven't done this in a long time, guys. I'll be honest with you. Last time I went on a Kohberger channel to see what's going on, it's probably been like half a year. And I went one time, and these guys were like, "Oh, these documents just got dropped. Let's start the timer." And they were having like a debate or bet as to what day he was going to get released. Like, I think he's going to be released on Monday, and one person's like on Thursday, and they had the chat going on about what day they were going to release him and stuff like that. And I was just like, you guys don't understand. Well, translucent. I still don't understand what it is that you had corrected me on. I've given you a chance here. Put a couple of stars. Let me know what it is, because I don't see it still. But I'm down to answer. I am what's the word I'm looking for? I've never backed down from anybody who's asked me a question or a thought or anything like that. Unless you're being really, really rude or things of that nature, then I'll just block you. But if you have a question or a comment and goes along with what we're saying, then let's hear it out. She must have been doing something bad. I haven't seen it. I appreciate the mods for getting all the anything that's negative out. I appreciate that. Yeah, thank you, Johnny. It's not so much a painful thing. It's just it's a it gets you mad to a certain extent, right? Like the amount of the crap that people do, and you know how sick some people are, and what they would do to other people, innocent people too, like little kids. So it's the guy got what he deserves, that's for sure. Do I think that BK has any remorse? Also, do you think he is a psychopath or a sociopath or both? Well, I'm not a psychiatrist or psychologist, so I couldn't even tell you which one it was, but he wrote down that he had trouble with feelings, remorse. He wrote down that he treats people as if he's an a-hole, especially his father, and he should treat him better. He looks at people as a sack of meat, including himself. So I do think he does have some problem with remorse based on the things that he wrote. Again, I'm not a psychologist or psychiatrist, so I don't have any licenses or anything like that to give any type of diagnosis. But in my opinion, I would say that then, which is why I also say I think he has trouble or problems with remorse and a lack of feelings, because I couldn't tell you anything specifically on that. But I would say that, what do we know? We know that he had put out a Reddit page on Discord asking to speak to ex-cons who have committed violent crimes. And he wanted to know a couple of things. He wanted to know why they committed the crime that they committed, how they felt, why they chose their victims, when they chose to do their crime, why they chose that day, how they left, how they exited, what got them caught, a whole 9 yards. Right now, if this is a man who is suffering with remorse and all these other things that he had written down in his youth, then you would suppose that other persons that are ex-cons or current cons that are in jail for violent crimes, if they're reaching out to him and they're talking to him and they have committed violent crimes themselves, it's probably likely that he's probably thinking that he might have maybe something in common, right? And I think maybe that could be a motive as to why, or a brief motive as to the starting point of this, getting to know people who are similar to him and going down that path. But like I said, I have no idea which one, or if either, or what diagnosis he would be or have or anything like that. Let's see. The Texas Ranger says, I agree, Daniel. It used to be interesting to see what they would come up with, but it's got boring now. I went at it from a place of curiosity. I wanted to see what the other folks on the other side or whatever, pro burger or not. When I created the term pro burger, I didn't create it as an insult. I just got tired of saying pro Kohbergers. You know what I mean? So I just started saying pro burgers. Just so that it's something that's easier to say and come out. But, I wanted to see, like, maybe they see something that I don't, maybe there's something that I'm missing that that they got. And yeah, and then that not end up being the case at all. But, that's why I was looking at it from a point of curiosity. And I haven't looked at one for a long, long time. I just get nothing out of it at this point. You're absolutely right. They will release Kohberger to the Idaho Department of Corrections. Yeah, I love that one. Let's see. I've been here in a while. Where are the two other guys? The other two guys are on, well, Blue has like a couple of jobs. I think he just got finished with one. And Jaime has been dealing with, not dealing with anything. He's just been doing a lot of trips and going back and forth out of town and stuff. So his time's been kind of cut. But I just talked to him not too long ago about coming back on. They might be joining me back on for a couple shows here in the near future. Not so much about anything true crime or anything like that. So you got to stick tuned for what it could be. It may be something to do with the extraterrestrial or supernatural, stuff like that. So they may be coming back here pretty soon. Let's see. My heart goes out to KMXA and E, plus the girls who survived and have to live the rest of their life with that night. 100%. A lot of people will blame the surviving victims, and I just, I don't know. I get the suspicion at first, right? But they've been investigated. They've been, interrogated. They had their phones and everything else downloaded. So, at a certain point, you got to be like, okay, they've been cleared, right? Just because you don't know the extent of everything that they have gone through doesn't mean that they haven't gone through a large extent of things. And, it's unfortunate that they have to deal with the loss of their friends in such a traumatic way and still have, so many people harping at them. It's unfortunate. Daniel, we'll be going to Boise for the trial. I'm going to try. I really am. I'm going to try to get out there for at least maybe the verdict, maybe some other parts. I may have a place to stay now. And so I may end up getting out there this August. Yes. Let's see. What's going on, Alexa? Good to see you. Good to see you. Tell Blue I miss him. I will. And Jay Turkey as well. Free Blue, free Hyman. I'm gonna let him know. In fact, I might end up getting some t-shirts that say hashtag free Blue, hashtag free Hyman. All righty. So now I'm back at the top, at the bottom. So I want to thank everybody. That's going to do it for us today. I want to thank everybody who has tuned in. Hold on one second. Great name, Mom. Welcome back. Thank you for tuning in. Says, as an Idahoan and Boise, I seriously can't wait for this trial to be done. Yeah, I can imagine. You know, I can imagine that as soon as this trial gets going, that how crazy it's going to be out there for you. Yeah, I couldn't imagine that. Yep. We need you to cover it out here. I'll be doing it. I'll be doing it. I'll get some time off and make sure that I go out there for at least the verdict, if nothing else. But all righty, guys, I appreciate you guys for tuning in and sticking with us. Thank you. Please hit that like button, hit that subscribe button, ring that notification bell. I'll be back probably tomorrow night after the hearing. I know that some folks will be probably airing it live. It's going to have some time where it's on, sometimes where it's off. What I'm going to do is I'm just going to gather it all in, take it all in, and give you guys the best synopsis and understanding that I have versus some, you know, just kind of speaking out of my rear, watching it in real time. You know what I'm saying? So till tomorrow, we'll see you guys then. Hit that like button, hit the subscribe button, ring that notification bells. With that being said, guys, I'm out of here. Good night. Stay safe. Stay warm.